Good evening and welcome to the resumption of the 20th meeting of the Joint Select Committee on Land and Physical Infrastructure. We are in the process of conducting an inquiry into the Trinidad and Tobago Inter-Island Ferry Service with specific focus on the procurement and maintenance of the ferries. The key objectives of this inquiry are to understand the current state of the ferry service in Trinidad and Tobago, to examine the policies and procedures used to acquire ferries, and to ensure that value for money is obtained, to determine whether due diligence govern the conduct of all aspects of the maintenance and management of the provision of the sea bridge service, and to determine the changes and challenges with respect to the maintenance of ferries. I would ask members and our guests to ensure that their cell phones are either turned off or placed on silent or vibrate. And to remember to activate your microphones when speaking and to deactivate them when you're finished speaking. I'm, of course, Stephen Crease, the chairman of this committee, and on my left is member.
Yes, Wade Mark, member, and good evening.
Good evening, Level Francis, member.
Franklin Khan, member.
Rushton Perry, vice chairman.
And sir, could you introduce yourselves for the record?
Okay, Mr. Chairman, my name is Winston Riley, and although I was invited as an individual, because of my role as chairman of the Private Sector Civil Society Group on Public Procurement, I specifically requested that the invitation is addressed to the group itself. The group, as you may be aware, consists of the two chambers of commerce, American Chamber of Commerce and the Trinidad and Tobago Chamber of Commerce. It also consists of the Manufacturers Association. It consists of the JSC, FITON, and two other members. One is a group called the Public Procurement Group in Trinidad and Tobago. It was formed just a few years ago, and CISL. Because of that situation, it was wise for me, if I'm going into public forum, to ensure that I have the cognizance and the understanding of the group of what I'm going into. Because if I speak, it will be assumed in the public domain that I'm speaking on behalf of the group. That's the first statement I want to make. The second statement I want to make is that there was need for clarification based upon what I heard here last time, and I could go through that clarification easily. And that is the State Enterprise Manual is not law. It is not an act of the government of Trinidad and Tobago, the state. And the second one has to do with Minister Franklin Khan. I want to clear this up quickly, right? I know him quite well, okay? On the question of the relationship between the board and the management, the minister has the power to allow the general manager, I think the term is used in the Act, to sit on board meetings. He has that power. So that kind of linkage that you're looking for is already established within the Act itself. Now, I'm saying those two things because in order to look, we were at a disadvantage. I have to apologize for not being here on the 4th because I was asked, I had to leave the country on the 2nd. And as soon as I was back, I informed the Secretariat that I am back and that I have no objections to appearing before the committee. But before that, what I had to do was to prepare a paper. At least the prepared paper to me will have been a guide to the committee as to how to proceed. And before one can talk about procurement in any reasonable context, one has to be clear about the framework under which one is operating. Because the issue of best practice is limited by your framework, your legal framework. So that's one issue that one had to be clear about. And then one had to be clear of what are you procuring? What constitutes procurement in the context of which we speak, right? Now, under the legal framework, I was a little taken aback myself when I realized that there are 34 conditions under the Act that specifies a role for the President. 34. Okay? In addition to that, there are 11 conditions that mentions the word minister. And of those 11 conditions, 7 conditions are specifically stated as conditions for the Minister of Finance. Right? And that is very important to me. And of course, what I had to do in order to get my position clear is to look at the Constitution and determine what the Constitution is stating when you have the word president, and there are no constraints on who is supposed to talk to, and what the Interpretation Act is saying in that context. And it is clear to me that the President acts on the advice of the minister or a minister that has the authority of cabinet itself. Except in the context, and of course this minister will have, where it states specifically that the minister is the Minister of Finance, and that goes to financial matters as such. It specifically states that. So whether or not the minister has direct authority to act, or he has to act through the president, right? The fact of the matter is that there is a certain amount of controlling interest with respect to the cabinet on the question of the commissioners in the Port Authority. So that became very clear to me. The protocol for handling that is another issue. That aspect of the protocol never concerned us, or myself, because we wanted to know where the authority lied and what are the functioning processes that can take place under the Act itself. Now, when we look at the legal framework, we understand the role of the President in appointing the commissioners, okay? And we understand that the authority may, with the written consent of the President, sell, demise, or otherwise dispose of any real or personal property or rights. What is the term rights? Rights, which went beyond property, right? Vested in by the Act. And then you move from that and you say, the powers conferred by subsection 1 shall be in addition to, that's not relevant, to and not in degradation of any powers conferred on the authority by section 9 2D related to the disposal of real personal property or rights. Okay? I'm going to try to move quickly along because I don't want to read all of this because you have it before you, right? And then, but the important issue here is that we are aware that a lot of the problems that we have here now are determined by the fact that a matter with respect to the Galaxia was not solved. That's the most polite way I can say. The issue with the Galaxia was not solved. Whether we consider it a commercial issue that was not properly negotiated, that's one, or whether it had to do with the hardline position of the people who were running the Galaxia that was forcing the government in the particular position, those things are not relevant in this given situation. The situation is that it was not solved. And in the context of that, what rights existed under the law if such a situation was not solved? Okay? Then we go to Section 83 of the Interpretation Act defines assets to include property or rights of any kind. In this context, it is necessary to determine whether or not the procurement or termination of a lease of a vessel is an acquisition or disposal of an asset which can be dealt with under procurement and procurement procedures. You leave that for the time being. In other words, you are dealing here with disposal of an asset. Was it done? You're dealing with public money issues in the context of the new Act. Was this done properly in a way that you can say that the people of Trinidad and Tobago, in the action that you took, that they took good care of public money or the assets that are being disposed of? That's the context in which this was being interpreted. And by the way, I make no interpretation because some of these, there are legal people who will have to look at this. And I thought that by outlining this in this way, I was giving some sort of guidance to your committee to make reference to these issues and make sure that these issues are addressed in any interpretation that you are given. Now, the other issue that I want to draw on, which has to do with the Act itself, has to do with the question of owner. And this is a very important issue because it then determines what you are in fact procuring. The Port Authority Act under Section 60 allows for the establishment of a government shipping service. Section 60 of the Act states the government shipping service means the service supplied by vessels owned by the state and engaged in the carriage of passengers and goods between Trinidad and Tobago. Section 61 of the Port Authority Act specifies that the authority shall operate the government shipping service. Notice the term operate, not procure. It's a distinction that we have to be clear. The Act doesn't allow them to procure. That doesn't mean that the government can't ask them to procure. Right? The Act allows them to operate the shipping service. Okay? Done by an owner. And I'm coming to the context of the definition of the term owner. Right? Yes, the government shipping service means the service supplied by vessels owned by the state and engaged in the carriage of passengers and goods between Trinidad and Tobago. Section 61 of the Port Authority Act specifies that the authority shall operate the government civil service, in this part referred to as the service, as the agent of the state, okay, and subject to such regulations as be made by the President on that behalf. In the regulations and in the definition section of the Act, there are two definitions for the word owner in relation to vessels, including any joint or part owner and a person who, through only the hire of the vessel, appoints the master and other persons working such vessels, and also includes the agent of the owner or hirer in the definition of section of the Act, master, etc. Okay? So one has to be clear as to what it is you are actually procuring. What I think the term they use here, because this is another factor I have to be clear on, we have no maritime engineers in our group, right? And therefore, any act, although we are talking about these acts, you have to find that anything you do also comes under maritime restrictions in accordance to international law, right? We couldn't address those, but I'm assuming that your committee will have had the kind of advice that were required in this context. Now, I want to repeat. The regulations and the definition section of the Act, owner in relation to a vessel includes any joint or part owner and a person who, through only the hire of the vessel, appoints the master and other persons working such vessel, and also includes the agent. You have to then define who is the owner of the vessel, and if the owner of the vessel that the port is engaged in management, whether that meets the requirements of the Act itself. Those are the concerns that we have. I am not drawing any conclusions. All I'm saying is that this was specifically set out in this way to give guidance to the committee as to some of the restrictions that are required. And it says here, there is need for clarity on the restrictions imposed on the service, the government civil service, government service, shipping service, by the definition of the term owner. Clarity is important in order to determine the procurement requirements in the context of procuring through leasing contracts or without management or employment requirements. And then there are other relevant laws which I quoted in the Act. It's quoted in the document I submitted. Charter purchase agreement is what I heard a lot about here, and one has to determine whether charter purchase agreements meets the requirement of the Act in accordance with owner. Who are the owners in the context of the agreements that we have, be it the Galaxy or the other boats that you are talking about in this context, right? Then I listed a series of other acts under which you have to come into understand as such, and like the Exchequer Act, the Shipping Act, the Integrity in Public Life Act, corporation sold. By the way, of course, the Minister Khan was clear in his statement that the Port Authority does not come under corporation sold in the same way as is defined, right? To the Minister of Finance. But however, the Minister of Finance has the power in terms of financial power to deal with the Port Authority. Right? So that is one area that I clarified very early. And all the bylaws of the state enterprises. Now, the other interesting aspect here is that when I looked at the Tenders Board Act, they are not quoted, they are not stated there. The Port Authority is not stated there. When I looked at the State Enterprise Act, the Port Authority is not listed there, right? But what happens in the final analysis is that the procurement regulations, they state quite clearly under that act that all state enterprises come under the act, but that is not law. Okay, that is what it also states. Okay, so one has to be clear as to what one is dealing with when one is dealing with the issue of procurement. The other issue that I wanted to draw here in the document I submitted was the question of the new act that is coming into play. And if that act came into play, whether we'll have been in this situation at all. I'm convinced that if that act came into play, which was supposed to be in place sometime in March, according to the last budget, if that act came into play, we will not have been in this position. All the discussions I heard there, procurement procedures, and so, that will not have been there. And of course, the point I want to dramatize in this presentation is that there is a question of memory that is lacking completely from all that I heard here today. And I listened to the first presentation that was done on the 4th of the month, right? There's a lack of memory. Where are the documents that are in place in the port that allows them to do proper procurement processes? There's no reference to that. There's reference to a lot of new procedures and reference to the State-Owned Enterprise Act. Procurement for the port is a specialized type of procurement. Therefore, anything that you get from the state-owned enterprise, if you're using that, has to be dovetailed to meet your specific type of procurement and deal with it in that context. There's no such documentation that I have heard of so far. That is a crucial aspect that is missing. That is an aspect that will be determined by the new procurement legislation when their handbooks are set up, when their regulations are set up, and they will be enforceable by law. So that any new administration that comes into play, any change of board or change of management that comes into play, there are documents in place which has to be followed, and it will have the power of law. That is what is crucial in the new regulations. It has the question of just setting up a new act is only one step in the process. The second step is allowing that act to operate in such a way that all the organizations of the state are set with a process, a memory, a process by which you could improve over time as such, and you could judge and measure the improvement. That is the strength of that legislation. And of course, what is important here is what happens at the level of your budget. And I am seeing, and I think there is a lot of talk about that, and that is the whole question of output budgeting. You must be clear on what your outputs are. Otherwise, the whole question of value for money becomes nonsense. Okay? And with those two situations in place, you will find that the whole issues in Trinidad and Tobago are going to go for dramatic improvement. Now, I also listed the phases that one should follow. Those are standard phases. But those phases have to be clarified or dovetailed to take into account what is specific with respect to the question of procurement of vessels. Now, as I said before, the Port Authority under the Act was supposed to do with managing the service. The procurement of vessels is not one of their prescriptive rights. But that doesn't prevent them from being involved in the procurement process if they are asked by the state. So a lot of issues you have here in which the minister is involved, of which the people in the Ministry of Works involved. And from what I remember rightly, a lot of those other vessels were done through NITCO, if I remember rightly. Those issues have no right arising in the context of this. The question that arises here is there not a conflict of interest with the people who are managing and the people who are involved in the procurement interest? And that is clear here when I listen to it, where Mr. Grant and the others went and do things which was different than people talking about Lloyd's. There's a whole host of procedures that are supposed to be followed if you are purchasing, and another host of procedures that are supposed to be followed if you are managing. And what Mr. Grant and they were involved in were processes that were relevant to the management process. And I'm convinced here that the purchasing process, the procurement process, was not properly done with respect to this whole talk about whether it comes from what part of Japan or not. That's irrelevant in the given situation. There is a conflict of situation here in the role that the Port Authority played. And that conflict of situation was never clarified in the processes that they were involved in. And that is the key to the problem inside here. And the other part of it, that the disposal issue was an issue that should have been handled with more finesse. If that was handled with more finesse, then I do not think that we will have been distributed. Oh, yes, you had corruption. That's a given. But when you have new management, you do not allow corruption to determine your behavior patterns. If you're in private sector, and this is a facility that you had to be working with in order to get your livelihood, you are not going to allow that facility to be shut down. You can't do that. You'll have to make absolutely certain that the facility remains working and that you have the negotiating power to make that facility work. Or if it cannot work because of what has happened, there are other things you can do. I mean, look at the American Army. They have plenty of vessels sitting down, you know. You don't have to look at the marketplace alone, you know. The American Army have vessels like Stupidus that you could get inside here tomorrow, right, to handle cargo. What is this all about? I don't know. What is this all about? People used to talk a lot about government-to-government arrangements, which I personally opposed and got the act adjusted. You could ask the Canadian government to lend you a ship for a particular period. What is this all about? So if the people that are involved in holding the gun to you believe that they could hold a gun to you, you're a state. You talk to other states, and you remove the problem. That is how I see this. It is a commercial issue that went foul. And the commercial issue was clouded by corruption issues. And in a management position, if you suffer, you have no right as a manager to allow corruption issues to influence your commercial decisions. That is how I personally see it. People may disagree. That is my view of it. Thank you very much. That's my opening remarks.
Yes, well, let me once again welcome you, Winston Riley. I want to thank you for the piece that you have done, and it would mean that at our level, we too might have to get some further interpretations as it relates to concepts and terms. I want to ask you if you could probably share with us, from your reading of the Act, that is the Port Authority Act, does the minister Well, first of all, I should ask, from your reading of the Act, what you see as the role of the board in the procurement process, the acquisition of vessels, and what or how do you see the role of the minister in charge of and has responsibility for the port, Minister of Works and Transport in that procurement process. Because I think there is a little problem that I would like you to clarify for us based on your interpretation of the law. Roles of the board, role of the management, and role of the minister in the procurement process. And as you are there, if you can give us your understanding of the concept or term president versus minister, as you outlined in your earlier presentation.
I am not a lawyer, and I raise these questions in the context that the legal advice is required by your committee. However, I do not see any section under the Act that gives the Port Authority the right to procure vessels. They give them the right to manage a service. That's what the Act says, is the management of a shipping service, okay? But that does not preclude them from procuring vessels because they're state-owned enterprise. They have, the government can ask them to do that. But they have to be aware that if they are doing that, they may be in a conflict situation. Or they may be breaking their own act. And that's why I raised it in that context, right? I am not going to give answers here. I am saying is that those are the things that one has to draw, because any decision that is made by the board in that context that lands up with a conflict situation or is breaking the act, every decision could be challenged in the court and could become null and void. Those are the issues that I think have to be addressed, and you should seek clarity. I am not a lawyer. I have just posed the questions, okay? In terms of the minister has powers. In accordance with the Act, he has powers through the president. I've looked at the Constitution, and the Constitution is clear on that area. Let me see if I could read it directly. Okay. The exercise of the President's function is determined by the Constitution of the Republic of Trinidad and Tobago, Section 34 of the Port Authority Act states. It says, notwithstanding Section 32 of the Exchequer and Audit Act, and I'm telling you where the contradiction starts. I deliberately put that to show the conflict, right? Notwithstanding Section 32 of the Exchequer and Audit Act, Section 33, 34, 36(1), and 37 and 38 of that Act do not apply to the authority. Now, if you understand that, that has to do with authority under the Exchequer and Audit Act, which is responsibilities under the President. Section 32 of the Exchequer and Audit Act states, subject to subsection 2, Section 33, and I say 240, shall apply to every statutory body, notwithstanding anything to the contrary contained in any other law. But there's an exception in the Act, stating that, right? Section 33 to 40 of the Exchequer and Audit Act deals with matters requiring the approval of the relevant minister on matters related to a statutory body. The Port Authority Act deals with similar matters requiring the approval of the President by the advice of the Cabinet or relevant minister as outlined in Section 81 of the Constitution. And then it goes on to say, that section says, in the exercise of his function under the Constitution, or any other law, the President shall act in accordance with the advice of Cabinet, or a minister acting under the general authority of Cabinet. This means that the Cabinet of Trinidad and Tobago, directly or through a relevant minister under the Cabinet's authority, advises the President as specified in the Port Authority Act. And I said before, there are 34 sections under the Port Authority Act in which the President has authority. And the President has specific authority to give general and specific guidance under the Act. I do not know about the protocol that operates in the context when that arises, or if that protocol demands a certain kind of approach to the President. I don't know. But that is something that I think any legal person on constitutional law could tell you. Or any action by any minister could be taken without discussing with the President. I don't know. But I think those clarifications should be got by this board, this group, this committee, before they move forward. That is my understanding. I am not making any statement with respect to that. The Act is clear. As I said before, there are only 4 areas where the word minister was about, and one of those areas was when the minister wants to make sure that the general manager sits at a board meeting. He has that authority directly. In the other cases, the word minister specifically refers to the Minister of Finance. Okay?
Now, when it comes to the issue of procurement, from your examination of the various acts, including the Port Authority Act, would you say that the Port Authority of TNT is responsible for issuing invitations for tenders to supply or for the supply of vessels for Trinidad and Tobago to operate, let's say, the sea bridge?
That, I think, needs clarification. That's one of the first points I made, right? The Port Authority can involve itself in any procurement procedure as such. Of course, by now, one is hoped that for a Port Authority that is operating for so long, that those procurement procedures will be well documented, refined in accordance with things they've done before, indicate what best practice, mistakes have been made, and corrections made. It's a long time. To be talking about their procurement processes now is a joke, right? You can't be involved in that when you have an organization that is spending that amount of money, right? And talking about procurement procedures and good practice now, right? I mean, what are we doing in Trinidad and Tobago? I mean, it's the same issue with PetroTrin. I'm shocked that is going on there. Anyway, what I'm saying is that in the context of the procurement of vessels, there may be a conflict of interest in the Port Authority role as managers and operators of the service, and also procuring on behalf of an owner. I'm saying there could be a conflict of interest. I'm not quite sure that the way they carried on the procurement and under what they call it the charter agreement is in accordance with the Act, so I don't know. But that there's need for legal clarification, and that is specifically stated in the document.
Yeah, because the reason why I asked that question, Mr. Riley, has to do with evidence that we got earlier on today, when we were informed as a committee that an advertisement in the newspapers issued by the Port Authority on the acquisition of a roll-on, roll-off passenger fast ferry for a 2-year time charter. The specifications were reduced by the Ministry of Works and Transport to the minimum, so that, for instance, interested parties who would like to submit their tenders for this particular service that they wish to supply didn't know what is the maximum length of the vehicle, of the vessel. That was not supplied to them. They did not know what was the maximum beam of the vessel. That was not supplied. And they did not know what was the maximum draft of the vessel. That was not supplied. Because we were told in evidence today that the Ministry of Works and Transport reduced the specifications to a minimum so that persons who applied and submitted their bids would have minuses on all these areas that I've just mentioned. That is the information that has reached this committee. So I wanted to really clarify this matter as to whether it is the ministry under the leadership of the minister under the Act that is responsible for procurement and determining the specs that should deal with that issue, or where does it really lie based on your study of the Act of the port and the powers of the minister, the Port Authority, the president of the country as examples.
Okay, Senator Smart, I listened to that discussion because I stayed here since 2:30. I almost went to sleep, if you don't mind, listening to what was going on here, with, of course, quite a few shocks as such. What I can say, first of all, is I have a copy of both procurement procedures, right? And of course, what was clear to me is that the Port Authority does not of itself have proper procurement procedures when it comes to the issue of vessels. And in the second case, that is the one that you spoke about, in which there is nothing on the document that went to the public domain, it is clear that people who are interested will go and purchase the relevant documents and get the specifications. Under the new Act, once it comes into place, that will be on the website. In other words, you could have the advertisement in one case and draw the people to the website to get the detailed specifications that are required. But a lot of these organizations now are using the purchase of documents in order to enhance their fiduciary conditions. Right? That's one of the things. That's an aside I've thrown in there, right? It is also clear that the Port Authority is acting under the authority of the ministry when it comes to the question of the procurement of vehicles, of vessels. It's clear that that's the authority. They're not acting in their own right with the normal authority to procure vehicles, either as state-owned vehicles or under charter agreements. Okay? I do not know where the charter agreements for the Galaxia was done, whether it was done under the Port Authority before, right? But I know that a lot of the other purchase agreements was done directly through the Ministry of Works or through NITCO of other vehicles that I'm aware of. And I only have limited understanding of that so far. So yes, they are under the control of the ministry. They're acting as an agent of the ministry for the procurement process. What I'm saying is that if you are acting as an agent of a ministry for a procurement process, and there are specific requirements for your operation under the Act, you have to be clear that in carrying on those two functions, that you're not in conflict. That's all I'm saying.
Member Ferry.
Thank you, Mr. Riley. Good evening, and thank you for staying. I was a bit depressed after the last group based on having 4 hours listening to a lot of information. And you've opened up with some very inspiring remarks and information that I do believe that there is hope and we could fix this. Mr. Riley, I have 2 short questions. It emanates out of data presented, but I will ask you it in a general sense for your response, because since you're not a material witness in terms of the procurement and maintenance, I expect you to give your opinion without diving too much inside of it. Can a permanent secretary sign a contract above $1 million in terms of the legislation, as far as you are aware? And if there are any exceptions to that rule?
That is a very interesting question. It is a question, and then I understand clearly now why the Port Authority went to the Central Tenders Board. Because the Permanent Secretary is under the Central Tenders Board Act. And the Permanent Secretary have to follow procedures under that Act. And there are two stipulations under that Act. One is if you are going for consultancy services, there are a maximum of $1 million. If you are going for construction services, there are a maximum of $2 million. But the procedure and the relationship with respect to the Central Tenders Board are clearly identified with respect to the committees that have to meet on that. It is not a responsibility of the Permanent Secretary alone. So you have to ask yourself in the first context whether that was carried on. Don't just look at this last set of regulations under the Central Tenders Board Act. There are two limitations. One is for consultants, which is $1 million. One is for contractors, which is $2 million. And there are procedures and the committee, and who sits on the committee in making those decisions. And those are the limitations of the Permanent Secretary. And I think that the Port Authority were, what I will say, they were quite, probably through the advice of the Permanent Secretary, they were quite alert to the fact that they had to bring the Central Tenders Board involved in the process. But whether they were involved in a manner that satisfied the requirements for due diligence is another story.
Second to that, in terms of appropriateness, right? I hope that's a word. There exists a portion of contracts that I saw were month-to-month contracts for these vessels at one point in time for various vessels. And this spin-off question to the first one, can month-to-month contracts exist that is expending taxpayers' money over $1 million without cabinet approval? Because no cabinet notes were sent, therefore I assume that means no cabinet approval. But you had month-to-month contracts in excess of $1 million. Is that something that our legislation would allow?
Well, if you're operating under the Central Tenders Board Act, that's strange. Mm-hmm. That's what I will say. Very strange. And then that will go straight to the Permanent Secretary in that context, if she's the one who's signing off those contracts.
Okay.
Right?
Because for these vessels, from the data we have that comes from the Warrior Spirit, come right back. Mm-hmm. As far as I recall, all the charter party agreements have been signed by permanent secretaries.
Yes.
So again, it comes back to your position in terms of a misinterpretation of the legislation.
Well, in this case, it's the Central Tenders Board Act,
right?
Not the Port Authority.
Not the Port Authority. So I thank you for those two responses, because I think it's going to be very relevant in summing up our report, because it sheds some light in terms of some processes. And clearly there's a breach of a whole number of processes emanating from the conversations over the last 2 weeks. And your two responses fits nicely into that, sir, and I want to thank you for that. Chairman, that's it for me.
I want to take this opportunity to thank you, sir, for greatly assisting us. And is there anything you wish to say before we close? Because we are about to close.
The one issue I would like to raise, because this has been my passion for the last 15 years, and that is the speedy implementation of Act Number 1 of 2015, which is amendments, as speedily as possible. That is the Procurement Act. We got it to the stage where the Act is in place. It is only partially proclaimed. It is at the place also where a series of promises were made with respect to the whole question of putting that Act into place. And I'll read to you what has happened to date with that issue. I hope I have that document here. There are a series of promises that were made. Okay. The present administration successfully advocated for amendments to the existing legislation and successfully amended the legislation through Act Number 5 of 2016, which was assented to on the 6th of June 2016. The Prime Minister, in his address to the nation on September 11, 2016, stated, "I give you the assurance that I have issued instructions to take immediate steps to operationalize the Procurement Act in the shortest possible time." The Attorney General on September 19, 2016, stated that the implementation is imminent. Apart from proclamation of the legislation, draft regulations accompanying the legislation are in substantial form. The regulator must be appointed by the President. The establishment of the procurement units in the state government ministries and the state enterprises are being built out as we speak. Where is the Port Authority in this? This was in September 19, 2016. We are in 2017. And they don't have any procedures in place yet that one can discern. The Minister of Finance, in the 2017 budget speech, gave on the 31st of March 2017 as the target date for full implementation. That is the date for full implementation. This is a straight quote. But the important issue here was no provision was made in the 2017 budget for the implementation and operationalizing of the Office of Procurement Regulation. Now, how could you make a statement like that for the March of the same year, and there were no requirements in your own budget for that issue? That raises a red flag to everybody who was interested in the speedy implementation of procurement. And I will say it went further. It went further in raising that red flag when the person who is operating as Minister of Finance objected to what was being proposed for procurement regulations at the Off Commission, just similar to what we have now. I think he has gone a long way, and he is acting, some people say it an epiphany moment, and he's trying to push it. But the question is, we are suspicious of what is going on at every level. Recently, salaries and remuneration arrangements for the board of the Office of Procurement Regulation was approved in May 9th in the Senate. Okay, that's the last time it was approved. Now, the question here is that the situation now lies totally in the authority of the President of the Republic. This President has an opportunity to do something that is unprecedented and has not been done by any president to date. He has, under the Act, he has to consult with the Prime Minister and the Leader of the Opposition. But he has to be assured that transparency takes place and accountability takes place. Nobody to date knows exactly what is in the President's mind in what is going on. And I will plead with him now publicly to make his position transparent to the population of Trinidad and Tobago. And he cannot do it himself. Otherwise, he will have to be held accountable for anything that take place. So the procedures for accountability have to be established. We had under the last administration, there was an oversight committee that was established by the last administration that was abandoned by the present administration. And the group that I speak for now, that is the Private Sector Civil Society Group on Public Procurement, advocated strongly for a process by which the Prime Minister, the President, could become accountable. That process was clear. We met the President on it because no process can go on under that act unless the President understood and agreed. There was in play at that time UNDP, who were giving all the training and advice for procurement in all the ministries and all the state-owned enterprises, and they at present doing the same thing under this administration. Okay? Our view of it is that since they have that understanding, and they were given that authority under the last administration prior to the act coming into operation, because their mandate was to make sure that even though the act didn't come into operation, certain procedures were set in place for better governance of our finances. The recommendation that was made was that the president should find a way where you could engage UNDP to do a form of advertisement, shortlisting, and give it to the president. In other words, if the shortlist was 5, then those 5 people will have been 5 people who the people of Trinidad and Tobago will have been confident that they had met the requirements for the procurement regulator or for the officers on the board of procurement regulation. 2 things have happened since then. By the way, we wrote the president hinting at some of these things before, so it's not going to be quite new to him. But what I'm saying offhand is that this is where we are. The president initially went out to a series of people, including the groups that we are in charge of, asking for recommendations. And then lately, he went internationally for the Office of Procurement Regulator. Right? This act cannot function without a board. It cannot function with the office alone. There is no money yet placed for the operationalizing of what is going to occur outside of the board. And we are hoping that that comes into the next budget, and there is a clear understanding of the amount of money that is required annually for keeping this procurement regulation active. Thank you very much.
Thank you very much, sir, for the deliberations you shared with us. I now declare the 20th meeting adjourned.